That's, I mean, that we can take that up on the record. It doesn't change anything.
I would not think that it would
Yeah.
count because it's not a conviction. What are your thoughts, Mr. Ralph?
I don't know if domestics fall under a special exemption like DUIs. I'm not sure.
Yeah.
I don't think it changes his overall history, right?
Right. I mean, I guess. Right.
Sorry.
Megan, does it?
I believe it does, but let me look in the sentencing guideline book, and then I can tell you what page I found it on. Or
I guess it would count if it was another DV battery because that could enhance it. But I just, and I guess that's why you'd score it. But I guess if he really had my concern was if he had another third person misdemeanor, he'd have been way further over.
Right. Yeah.
Okay, so it says diversions are not convictions and therefore not included on criminal history except as otherwise provided by law for current convictions of current convictions. Okay, I might have made a mistake.
All right.
Manslaughter, DUI, domestic battery, and buying sexual relations.
So we can strike it for this PSI is what we're saying.
Does it affect the score?
No, but
it's just an unscorable.
Right. It just needs to go to a U instead of a P for this.
Yes.
Gotcha.
Right.
Okay. Then I'm ready.
Okay. All right.
And Klein, I guess just before we get going, I've only got 4 days total of him being in custody on this case.
That sounds right.
Okay.
All right, let's be on the record. Case number 2019-CR914, caption State of Kansas versus Isaias Vela. Would the parties announce their appearances, please?
State of Kansas appears by and through Assistant District Attorney Garrett Ralph.
Klein Boone appears on behalf of the defendant, Isaias Vela, who also appears in person.
All right. We're here set down for a sentencing today. The record should reflect that the parties appeared in court last on October 30th, at which time the defendant changed his plea from one of not guilty to guilty. The court inquired and accepted that, ordered a pre-sentence investigation, and set it for sentencing. I've received that PSI. The critical findings are as follows. The primary offense of conviction is one of aggravated assault on a law enforcement officer. That's a severity level 6 person felony. The defendant's criminal history score was found to be that of D. That would leave him with a presumption of prison and a presumed underlying sentence of 32, 34, 36 months. If he has to do that time, he'll be eligible for 15% good time credit and subject to 24 months of post-release supervision. The special rule that applies is number 3. That's based on the aggravated assault of a law enforcement officer. If he's granted probation today, it would be for a period of 24 months to community corrections. The second count of conviction is one of battery against a law enforcement officer. That's a severity level 7 person felony. For scoring purposes, the defendant's criminal history score is I for secondary counts, which would leave him again with a presumption of prison, a presumed underlying sentence of 11, 12, or 13 months. The special rule in this conviction is 34. That's battery on a law enforcement officer. The same 24 months post-release and 24 months of probation if granted. We had a discussion before we came on the record. It appears, although it does not change the criminal history scoring, that there was a diversion for a domestic battery that was scored as a person misdemeanor. As a diversion, it's not a conviction. So there are reasons to have it in there for enhancement of any subsequent settings, but it should be scored as a U or unscorable for purposes of today's hearing. With that, Mr. Ralph, I would ask you, did you have a chance to review the PSI? And other than that one correction, do you have any corrections, additions, or challenges?
No, Judge.
Same question.
Sorry. I have reviewed it, and no, I have no objections or corrections.
Thank you. Compound questions. Mr. Boone, same compound question to you.
Correct. We reviewed it and we agree that, other than the noted correction we made, that it is proper.
All right. Then given with that one change, I will adopt the findings for today's hearing. Mr. Boone, you filed a motion for a downward dispositional departure. I'm not quite sure who Dedrick Jones is and why she wants a departure, but I will assume that you meant your client, Mr. Vela, and I would hear your comments on that this morning.
Right, Judge, I did catch that. Thank you. Judge, I would just ask that this was a negotiated plea, but most importantly, my client, accepted responsibility. I think we actually maybe pled no contest because of the factual basis we were, trying to get to avoid registration. My client accepted responsibility by, pleading no contest. I also believe that he's amenable to probation and can comply. He also, as I've indicated, that he waived his rights and didn't make the state of Kansas come in here and, put on evidence in this case. And I think that alone, the court could find as substantial and compelling. And I would just ask the court to adopt this downward dispositional departure. And most importantly, by law, these sentences have to be consecutive. He has a lot to lose if he cannot comply with probation. And I think it's a proper plea. And I know that, this incident arose out of a time when my client fell asleep. The neighbors called the cops. There was, the state of Kansas alleged he'd been drinking too much and was woken suddenly up by the police. And I think that's what startled him and caused this unfortunate incident. I would also add to the court that my client, in doing so, his interaction with the police that day broke his foot, and he learned a valuable lesson of how to act and not act with the police moving forward. So I'd ask the court follow the plea agreement.
Thank you. Mr. Welf, your comments on defendant's motion and anything else touching upon sentencing.
Judge, this was an agreed upon plea. I've talked to law enforcement that were involved in this. They thought that the plea was appropriate. And I would just ask that you adopt the plea agreement.
All right. Mr. Vela, now is your opportunity to tell me anything you want me to know in mitigation of your sentence today.
I'm making mistakes, I regret it, and I don't want to go to prison. I want to be out. I want to be working. I got a child that's 4 years old, and I got a lot of responsibilities, and I'm the only one that support my house. So.
All right. All right. Thank you, Mr. Vela. Mr. Boone, do you know any legal reason why I should not now proceed to sentencing?
No, Judge.
All right. Well, I am going to consider and grant the defendant's motion for a downward dispositional departure. For the substantial and compelling reasons to support that, I will adopt the comments of counsel today, as well as those arguments set out in his motion. Therefore, the defendant will be sentenced thusly for count 1, which is a aggravated assault on a law enforcement officer, severity level 6 person felony with the criminal history score of D. The defendant will be sentenced to a period of 34 months in the Department of Corrections. If he has to do that time, he'll be eligible for 15% good time credit, subject to 24 months of post-release supervision. As to count 2, the battery against the law enforcement officer, a severity level 7 person felony with the criminal history score of I, the defendant will be sentenced to a period of 12 months in the Department of Corrections with the same 15% good time credit and 24 months of post-release supervision. For both of these counts, the defendant's application for probation is considered, and it is granted for a period of 24 months to community corrections. By operation of law and the judgment of this court, these 2 counts shall run consecutively to one another. All right, let's get on to Mr. Vela. You mentioned your the child you have at home. Does that child reside with you?
Does he live with you, the child?
Yes.
Okay. And how old a child is that?
4.
4. The home you're in, do you rent it or do you own it?
I'm renting it.
All right. What do you do for a living?
I am an electrician.
Oh, okay. Are you in a union shop?
No, I work for my brother.
Okay. All right. Is it your brother own a company and you work for that company, or do you just work together?
He owns a company, but
All
yeah,
all right. Do you have like a yearly salary? Does he pay you hourly? How do you get paid?
all depends on the jobs. Sometimes he get good jobs, and that's like when I make money. But sometimes, like right now with the virus, it's been real slow, but it's been.
Do you have an idea about how much a month you average?
Email received.
I make uh like $2,500 to $3,000 a month, something like that.
All right. And Mr. Boone, you are retained, correct?
Correct.
All right. Well, look, I think that there's a couple of things going on here. The defendant has not a lot of money and a lot of responsibilities financially, and he's also going to have to pay the database fee, the DNA database fee, given that this is his first felony conviction. I want to make sure that that's accurate.
It's not, Judge. He had one out of Johnson County. I don't know if he paid that fee or not. He may have.
All right. How old was the Johnson County one? I can't remember on that.
2015.
Oh yeah, he would have paid it. All right. So that's waived. All right. That makes me feel better. I'm going to assess court cost supervision fees. There will be no database fee as he's already in there. And there's no request for restitution. He has retained counsel, so it's just going to be that amount of money. I think if I order $50 a month, that should get him paid off well before his probation is over. Mr. Vela, if I ordered you to pay this amount, it's going to be about 300, a little more than $300. You think you could make $50 payments on that until it's paid off?
Yes, sir.
All right, that will be ordered. All right. Other than that, Mr. Vela, I need to tell you that you have 14 days from today to appeal anything you don't like about your sentence. You may also be able to seek expungement after a period of time following successful completion of probation. As a convicted felon, it's prohibited for you to own or possess a firearm, and certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. You understand all that?
Yes.
All right. Remind me, folks, when we did the factual basis, was there a gun finding in this case or not?
No, Judge. There was no firearm used.
All right. So there's no registration requirements.
No, there's no deadly weapon finding.
All right. All right. So then I would ask you, Mr. Ralph, I think I've covered everything. You all mentioned 4 days of jail credit, which will be granted to the defendant. Anything I failed to cover today?
No, Judge.
Judge, what was the probation period for? Is the probation for the 2 counts going to run concurrent to each other? The jail
Probation
sentences
always,
run
yeah,
consecutive?
probation always runs concurrent to one
Okay.
another. So it's a 24-month period. Okay. All right. If there's nothing else, then we will be adjourned. Mr. Vela, good luck to you. Walk this probation. You got a long underlying sentence, so you don't want to have to go do that, okay?
Okay. Thank you, sir.
Hey, Judge. Megan,
Yes.
do they want him to come up there today, Megan, or do you know?
Here's what he needs to do, Klein. I'm going to stop the live stream so I can give you a phone number.